Welcome, and thank you for joining us for the next installment of our webinar series. For those of you who are not familiar with Franczek P.C., we are a law firm of approximately 30 attorneys who focus on labor and employment and education law. Before we get started, there are just a few housekeeping items to address. To the left of the presentation slides, you have the ability to type and submit questions. Please feel free to ask questions throughout the program by using this feature. Because we have a lot to cover, we may not be able to get to all of the questions, but we'll try to follow up to address outstanding questions after the webinar. Everyone logged into today's program will receive an email that includes a link to the recording of the webinar, as well as the presentation. All right, let's get started.
Thank you, Kendra. My name is Jennifer Smith, and along with Kendra, we're your presenters today. We are both partners at Franczek and specialize in education law. So why are we here? Well, this little girl's head looks like it's exploding with questions, and that's pretty much how we felt around the office, and based on our emails and phone calls that some of you have felt as well. Although she seems pretty zen about it, and hopefully by the end of this presentation we'll be more zen about the emergency regulations too. So with that, we'll get started.
All right. As you know, the Chicago Tribune and Publica, Illinois conducted an investigation into the use of an isolated timeout in Illinois schools. This was published on November 19th. After the article was published, the state superintendent acknowledged that the practices of isolated timeout and physical restraint have been misused and overused to a shocking extent.
So just one day later, responding to the article, Governor Pritzker called the isolation of children in the state appalling and said he directed ISBE to make emergency rules for schools. He also announced plans to work with legislators to make the rules into law.
All right, so the emergency rules were issued then on November 20th and effective immediately. So we've all been scrambling to figure out what do the rules mean and how do we comply. These emergency rules are effective for 150 days, and during that time, ISBE will be moving forward to propose permanent rules. ISBE has also let us know that they're going to be putting out an FAQ soon, so we're on the lookout for that, and we'll have more info for you when it is released.
So the main question that I've been getting is how does this affect my district? So we see the emergency rules, and we're going to go through some different steps that kind of a self-assessment of how do you determine what you need to do in response to the rules. And the first step is to consider your district's own practices historically and whether these rules will impact on those practices. So first step to that would be to consider, do you or has your district used isolated timeout? If you did, you can't, and if you haven't before, you can't start now. The key factors to knowing whether you used isolated timeout are whether you locked students alone. So if they were locked and alone, then that would qualify as an isolated timeout previously. That was permitted by the law previously. You had to meet certain requirements. So just because you did this does not mean you violated the law, but that's how you know, okay, if we did that, if that is part of our practices, then this is a change for our district, and we need to respond to the rules in some way.
So in addition to this emergency rule, we also have new proposed legislation that would prohibit seclusion. The proposed law defines seclusion as discipline management practice or behavior management technique in which a student is confined in an enclosed space that is designed solely to seclude a person, regardless of space or dimension, whether it is a box, a closet, a room, or any other specially designed locked or unlocked space. So this bill is not yet a law. This is still going through the legislative process. Sort of unhelpfully, the bill uses seclusion, where the emergency rules used to say isolated timeout and now talk about timeout, and so we have sort of different terms. At the same time, I think both this proposed legislation and the emergency rules are aimed at stopping the practice that was previously permitted, but that was detailed in the article that of holding a student alone in an enclosure while that student's in crisis. And so I think, keeping that purpose in mind can help us as we try and figure out and shed light on our next question.
So even if you or your district did not use isolated timeout, the next question is, do you use behavior management techniques that qualify as not isolated timeout, but just timeout under the new regulations? Once ISBE eliminated the word isolated, the types of interventions that might possibly be considered timeout became quite broad. And if you're using methods that qualify as a timeout, then the new requirements could apply. So let's dig into that definition. The regulations state that timeout is a, quote, behavior management technique that involves the monitored separation of a student from classmates with a trained adult for part of the school day in an unlocked setting. Reading just that definition, the term timeout is very broad and could encompass a wide variety of behavior interventions. And I see we have a question to that point, giving different examples of does timeout now apply to sports, sports breaks or sensory breaks, and we've got other questions. Does it apply to just in-school suspensions, different things like that? Based just on the language of the rule, you can certainly see why there is a question there, and you would possibly include these kinds of common interventions. But we do not think that is the intended result. ISBE has informally shared that that is not the intent of the emergency rules, and we do not advise on such a broad application of the emergency rules.
Right, and I think, part of why we come to that conclusion is that the emergency rules continue to provide requirements for what that enclosure looks like, so that place where the student is having the time out. And those requirements include that the space needs to meet the health and safety requirements related to building and construction, have the same ceiling height as surrounding rooms, be big enough for the student and the adult, be free of electrical outlets, wires, and materials or objects that a student could use to harm themselves or others. And especially that last piece there really indicates that we should not consider some of these more common interventions to be a timeout. So things like sending the student to the principal's office to finish some schoolwork, sending the student to see the social worker to process an incident, bringing the student to a sensory room, or other types of breaks and interventions that you do use with students on a regular basis, we would not consider to be a timeout because they're not going to an enclosure that meets those requirements. Those are just general rooms. The same analysis would apply if a student is in class and having some sort of behavioral episode and the teacher needs to clear the other students out of the classroom in order to keep the student safe. I don't think we consider that as a timeout either because that student is remaining in the classroom, which obviously has electrical outlets and objects the student could use to harm him or herself. So I think that's a different type of intervention, and it might still be something you want to document and keep track of, but it's not going to fall under this definition of timeout.
So again, how we're applying the new rules is to a situation that we would previously call isolated timeout, but now there's an adult and the door is unlocked. So, think of it in that way. We're a district that previously used, or this is a technique that previously was isolated timeout, but we're simply, instead of sitting outside the room, the adult's going in the room and we're not locking the door. Okay, you're definitely falling now under this new regulation. And with that,
so we can just sort of review here. The requirements now for timeout are that a trained adult needs to be present, the door needs to be unlocked, and the enclosure needs to meet the requirements that we just discussed. Additionally, the timeout cannot continue for longer than necessary, which was previously the case as well. And no less than every 15 minutes, the trained adult needs to assess whether the student has ceased presenting the specific behavior for which the timeout was imposed. Now, that's a really specific requirement and thing that the adult needs to be looking for. But I don't think that necessarily limits how long the timeout can last. So it might continue to be necessary to have a student in timeout, even if that original behavior has ceased, if the student begins a new behavior that also warrants a timeout.
So another question we got that follows that is when a student's in timeout, they've calmed down, they're ready to go back to class, but they're refusing to leave. They won't go back to class. How is that documented? So again, I think in that scenario, we're outside of the realm of timeout because the door has been opened, the staff member is moving and directing the student to leave the room. So you're not excluding, the timeout period is where you've put the student in the room with the adult and they cannot leave. That's the definition. We've ended the timeout, the student can leave, you're inviting them to leave. Now you're still having some behavior management and you're going to go through whatever the behavior, the BIP probably is for that student on how to address insubordinate action where they won't follow the directions. But until the student escalates to the point where you're requiring the student to stay in the room again, you're outside these new rules.
So as we move from talking about timeout to restraint, I want to take a minute to look at the requirements that apply to both of those interventions. So the emergency regulations require that timeout and physical restraint be used only for therapeutic purposes or as a means of maintaining a safe environment for learning to the extent necessary to preserve the safety of students and others. Therapeutic purposes is a new phrase in the emergency rules, and it's not defined. Until we get further guidance from ISBE, we think a conservative approach is warranted here. So if you're thinking about using timeout or physical restraint for therapeutic reasons rather than for safety reasons, we do recommend that you base that plan on the recommendations of an evaluation that explains when you're going to be using these types of methods and why it's therapeutically indicated and how it will actually benefit the student. So I think this goes beyond just documenting it in your behavior plan as a behavior management technique. If it's going to be a therapeutic use, then it really needs to be a therapy or in some way a treatment for the student to benefit their emotional functioning or their behavioral functioning. So I think there's really a distinction there between that therapeutic side versus the behavior management side, and that needs to be documented in the IEP in some way.
So we also note that while the regulations provide for the use of timeout and physical restraint for therapeutic purposes, the ISBE form to be completed by staff requires staff to check only one of two reasons for the intervention. One is that there's imminent danger to self, or two, there's imminent danger to other student or staff. So they don't have a separate check mark for use for therapeutic as a therapy. So because the rules do allow this, if this is going to be your practice, and like Kendra said, you've documented that it is needed for a therapy or for a therapeutic purpose, then you need to write that separately. You need to go a little bit outside the parameters just exactly there on the form at this point and clearly document that you are using it for a therapeutic purpose. The phrase, and again, so remember, because right now you're asked to check two things, imminent danger to self or imminent danger to others. The phrase imminent danger is not used in the regulations, but appears to be ISBE's interpretation of when a timeout would be necessary to preserve safety of the student and others. And so in situations where the risk is not immediate or other interventions are available, timeout or physical restraint would not be appropriate. The form does not include a box, again, on the therapy. You have to pick danger to self, danger to others, and otherwise you're just going outside the boxes.
Okay, so talking a little bit more about the physical restraint piece. Your next question to consider when thinking about what changes you may need to make to comply with the emergency rules is, did your district use prone or supine physical restraint? If you did, these holds are no longer allowed. And we've got some diagrams here, but just for explanatory purposes, supine is flat on your back, face up, and prone is flat on your stomach, face down. These holds are part of the progression of physical restraints used in some methodologies that I know some of our districts and co-ops use, including MENTA. These procedures cannot be used at this point under the emergency rules as they currently stand.
So, as many things have been evolving, this is one where we expect some further evolution, and it's our understanding that ISBE's received a lot of feedback from specifically private schools that they will be unable to manage some student behaviors without these techniques safely, and that the students' placements are being terminated. Accordingly, we understand that ISBE will be shortly posting an amendment to the emergency rules that addresses the use of prone and supine restraints and possibly allows them in certain situations to preserve, at least for the time being, those placements. We don't know, but we anticipate that is not going to be the end of the debate and discussion on these types of holds, and that it may very well be that even if allowed for a transition period, that the ultimate final rules do not allow these techniques. Now, a lot obviously still has to happen in the analysis there, but like we said, do not be surprised to see new amendments on this particular issue shortly.
One other thing to note there is that physical restraint does, the rules prohibit the use of techniques that impair the student's ability to breathe or speak normally, which hopefully won't be a change to anybody's practices. So thinking through this, now that we have some additional limitations on the types of behavioral management techniques that were previously available that are not anymore, what can your school do if the team can't safely manage a student's behavior with the tools that are currently available? For instance, what if a student is in timeout and becomes physically aggressive toward the adult that's monitoring the timeout, but physical restraint for whatever reason is contraindicated? And so now that adult who's monitoring is in danger by remaining with the student. Or what if you have a larger high school student who's banging his head against the wall and physical restraint short of a prone or supine position is not able to prevent that behavior or de-escalate the situation? I think in the immediate term, there are not a lot of really good options. The school can call home and ask the parent to come pick the student up, call staff, or call the police. These are certainly not desired outcomes. We'd much prefer to be able to manage student behavior in the school environment and to get that student back to where they're available for learning. But in some cases, it might be necessary to maintain safety.
Looking ahead, you can start planning IEP meetings for students you expect will present behaviors that will be difficult to manage under the new rules. Invite in the resources you have, or whether it's a BCBA, a school psychologist, a behavior specialist, whatever expert you can access that might provide the team some other tools or ways to figure out to address the student behavior safely in that environment. We do expect that, there's a placement issue here. If a student cannot be managed safely with the tools that are available in a setting, then you might have to look to other settings.
Right.
One other question we've received, if a parent has to pick a student up, so we just said one of your options is calling the parent and you ask the parent to pick the student up, is that a suspension? Yes, it is, and this would count, so as far as your paperwork requirements, you do need to document that as a suspension day or a partial suspension day.
Okay, so the next consideration is, do you have students that are outplaced at a school that uses these techniques? If your district does, you're going to want to contact that school about compliance with these new rules. The new rules do apply to ISBE-approved placements that are serving Illinois students. So the obligation to complete the reporting requirements about incidents of timeout or restraint is on that private school. And if the private school is using prohibited discipline or behavior techniques, its ISBE approval may be in jeopardy. But you as a district still have an obligation here, because if the private school is violating the rules, this may be or may lead to a violation of FAPE for the student. So if the student is being denied FAPE, that then falls back to the district, of course. And this includes if the school is not sending home the required form, which might be a procedural violation that's limiting the parent's participation, which would then also lead to potential liability for the district.
So now, as we've gone through this, you may be feeling, yeah, this only applies to us in a limited way, or wow, we have a lot of work to do. So what is it that your district is required to do? Well, a first and primary step is you must have a policy. You've always had to have a policy, but now in particular, if you don't have a policy, it's the time to get one. That is a prerequisite for any of the either timeouts or restraints to be used for behavior management. The rules also continue to provide detailed documentation requirements for the use of timeout and physical restraint. ISBE has provided a required physical restraint and timeout form. Previously, much of the information on the new form, not all, but previously it was largely required, although there was no form. So your own documentation isn't going to look like this exact document historically, and now you are required to use this document. You need to send the form to ISBE within 48 hours and to the parent within 24 hours. So previously, the information provided to the parent was more limited, and the full record that the school was required than the record that the school is maintaining. Under the new laws, the full report must be provided to the parent. Also, previously, parents had the option to waive receiving written notice of each incident of timeout or restraint, and this option has been removed. So if you're thinking about students where this is a daily or at least weekly part of what needs to be done to manage them and support them in the school, there could be a lot of document. This is a very document-heavy now process, and it was before, but it especially is going to be now.
Absolutely. A few things to note about this form that actually, I think, go beyond what was required previously and maybe even beyond what is in the emergency rules. The form does include a place to mark the date and time the nurse evaluated the student, including the nurse's signature and comment. The rules don't require the nurse to evaluate the student after each use of timeout or restraint, but if there's any indication the student was injured during the incident, the nurse should evaluate the student. If you don't have a school nurse, one option is for an administrator to check in with the student and document if no injury is apparent, or if the student may be injured, to certainly call the parent or appropriate medical personnel. The second place that I want to bring to your attention is the form includes a question, was a post-vention meeting held with the student to process the events leading up to the incident, to develop alternative solutions and plan for reentry into his or her routine? This meeting is not required in the rules, but it may be a helpful practice for some of your students, and so that's sort of a decision your team will make depending on the age and maturity of the student and exactly what happened. The third thing to note is that the form includes a place to provide the date and time of the team meeting convened within 48 hours to discuss recommended changes in approach or follow-up needed. There's also space to document who attended that meeting and the future actions to be taken. The rules require documentation of a description of planned approach to dealing with the student's behavior in the future, but this form adds specificity to how and when this will be determined. Know that because you have to send this form to parents within 24 hours, but you have 48 hours to document and hold a meeting, you might have to send parents an updated form after the team meets to go over these questions.
So one of the major concerns raised in that Publica news story that kicked all this off was that these interventions were used even when the student was not presenting a safety risk. It is not clear whether that is because the students where they were reporting actually weren't. We obviously don't know whether the full context of what documents they were reporting on and what those forms look like. But one thing we suspect is perhaps the staff that were completing the form were not accurately capturing their safety concerns and how they described the incident. Or we generally have that concern. I guess I can't specifically speak to what was being reported on whatsoever, but in general, I have a concern that sometimes the way we describe things is not fully capturing what's actually going on. So a very key component will be when completing this 24, 48-hour form, we need to capture what is the safety concern concretely in a way that anyone picking up the form can understand why you did what you did, why that safety intervention was required or that therapeutic intervention was required. We fully expect, and I would expect these forms are all being sent to ISBE. I would be shocked if they weren't FOIA'd again down the road. So prospectively, we need to make sure that if your form is on the front page of the Tribune, you feel good that it documents why you're using that form of behavior management.
So speaking of providing this information to ISBE also is requiring that all schools submit documentation of the use of isolated timeout and physical restraint from the last several years. That's 2017-18 up until now. And these records are due to ISBE by December 20th, which doesn't give you a whole lot of time. As we've mentioned, ISBE did not previously have a required form, so your documentation may look different from what is currently required. You should send the reports that you have. You do not need to try to kind of convert those onto the new form. Send ISBE the forms that you were previously maintaining. If those reports are scattered among student records as opposed to housed in a central location, which is what the regulations do provide for, you're probably going to want to just talk with team members who are involved in these types of interventions to figure out where are the records and take steps to collect them so that you can get all of the information to ISBE.
So the new rules do require that adults involved in the use of isolated timeout and physical restraint be trained in de-escalation, restorative practices, and behavior management techniques, in addition to training that was already required by the rules. These topics may have been included in training that you've already done, but that should be verified. Additional training may be warranted to ensure all staff involved with these techniques know about the rules and the requirements. However, as a reminder, there are times when physical intervention, I'm going to call it, can be used by untrained staff in momentary periods to protect students. And so I'm going to read exactly the exception that has always allowed this, and it's still allowed. And that's that physical restraint does not include momentary periods of physical restriction by direct person-to-person contact without the aid of material or mechanical advice, accomplished with limited force and designed to prevent a student from completing an act that would result in potential harm to self or others or damage to property, or to remove a disruptive student who is unwilling to leave an area voluntarily. So just to crystallize that, if a student is about to step into a busy street, a staff member next to that student is untrained in any kind of physical restraint, we don't just let the student step into a speeding car towards them. We can grab the student, pull them back. That is not a violation of these rules. It never has been. You can continue to do that.
Yep. Okay. The rules previously provided that after the first 3 uses of timeout or physical restraint, a meeting needed to be convened to review the effectiveness of the procedures and prepare a behavior plan, and to consider the need for alternative programming or for special education. The new rules require that such a meeting occur after every 3 instances of non-therapeutic timeout or physical restraint. Again, because this therapeutic piece is not really defined, we do recommend that teams meet after every 3rd use of timeout or restraint. And that meeting should be held as an IEP meeting for students who have an IEP.
Great. There is a new complaint procedure.
Yeah. Let me say one more thing about the meeting. It's just that it is an IEP meeting. Parents need to be invited and informed about what's going to be discussed. If the parent doesn't want to attend, that's fine. The team does need to go ahead and still hold and document that meeting and then send the information to the parent.
So the emergency rules add complaint procedures. It's similar to state complaints that you're familiar with under Article 14. The rules provide the state superintendent will issue written decisions and findings of fact and considerations, as well orders for any action, including technical assistance. So these will be new complaints, but I expect they'll be very similar to the complaints that you are used to under the state complaint process.
And ISBE is proactively encouraging parents to file these complaints if they have concerns about past practices. So I would not be surprised if we start seeing these come in.
So with that, and thank you for your questions. I hope that we addressed many of them, but we did want to respect your time. Coming soon from our law firm, we have a few exciting announcements, and including on this topic. First, we're excited to announce the launch of our Education Law Insights podcast. The podcast will provide you with insight into the latest education law developments and analysis of pressing legal issues in K-12 and higher education. And it premieres on Thursday. So we're posting our webinars as podcasts after live presentations, so you'll have easy access to that content. This Thursday's episode will be on the legislation of marijuana and the impact on schools, and today's webinar will be posted on December 12th. We look forward to more of those on Thursdays.
Additionally, we're pleased to host a complimentary full-day conference addressing compliance with the laws governing the use of restraint and seclusion in Illinois schools, including the recent rules that we discussed today. Highlights of the program include analysis of these rules, exclusive insight from the reporters who investigated and authored the Chicago Tribune and Publica, Illinois article that led to these changes, and a training in the collaborative and proactive solutions model by the nonprofit Lives in the Balance. This program is offered by Franczek in partnership with the Education Law Policy Institute at Loyola University Chicago School of Law and the Parent Side Special Education Practice at Grunt and Levitt. Many of you know Mickey Moran.
So thank you for joining us today. We hope you found today's program helpful. Our next webinar will be on December 10th at 10 a.m. We will provide an update on Title IX and employment issues. You will receive an email today with the link to today's recording and presentation, a link to registration for upcoming webinar and conference, and the information where you will find the new Education Law Insight podcast launching Thursday. So don't forget to check out our blog, where we've been trying to push out all the updates and certainly we'll do an update once the amendments to the emergency rules come out, possibly today. So thank you.